The record in the matters 24 SCAP 104, 24 TR 469, 470, 471, and 472. State of Wisconsin, County of Burnett versus Gavin Jones. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Jones appearing in person with counsel Gregory Amon.
Let's pause right there. 4 charges, 2 states, and a joint recommendation already agreed upon. It's not your everyday courtroom setup. So why is Gavin Jones being offered this deal? Buckle up. The details behind this plea are more emotional than you'd expect.
And sentencing, the parties have reached an agreement. Mr. Amon, can you please recite it for the record?
Yes, Your Honor. Mr. Jones will plead guilty to amended count 1, amended to resisting or obstructing with a motor vehicle in violation of Wisconsin Statute 346.04, parens 2T, which is a Class A misdemeanor. Joint recommendation is that sentence will be withheld with your probation. Conditions will.
On paper, this might sound like leniency. It's no jail, just probation. But look closer. Gavin's conditions include substance use monitoring, mental health assessments, and DNA collection. That's the justice system quietly signaling, we know this might be deeper than what's on the surface.
DNA surcharge sample and the other charges and the traffic matters will be dismissed and read in.
Ms. Rockow, with this agreement that's been reached, why is it in the public interest, as it was charged as 2 serious felonies and a low-end misdemeanor, to have it be resolved to this resisting, obstructing with a motor vehicle, Class A?
Your Honor, I reviewed the facts as well as Mr. Jones' criminal history in both Minnesota and Wisconsin. He has no criminal convictions on his record whatsoever. This incident began in Minnesota. He was traveling at a very high rate of speed in Minnesota. Continued into Wisconsin, where he was ultimately stopped. I think the state would have a pretty difficult time at trial proving the recklessly endangering safety based on the facts. He was simply just speeding and disobeying law enforcement lights and sirens.
Now we hit the turning point. A high-speed pursuit that starts in Minnesota and ends in Wisconsin. But this wasn't Grand Theft Auto. It was a young dad speeding with desperation. The DA admits proving reckless endangerment might not stick. Why? Because this wasn't calculated danger. It was emotional chaos.
Mr. Amon about a resolution that would avoid a felony for Mr. Jones, as this is his very first criminal conviction. And Mr. Jones was wanting to take responsibility for his actions in pleading to a Class A misdemeanor. I think that the background for what was going on with Mr. Jones will provide the best context, and I'll let Mr. Amon talk about that. But it's my understanding that there was a family situation happening, and Mr. Jones was aware that if he was pulled over, he wouldn't get to his daughter in time. And that would have some pretty serious implications for his life and his.
And now the truth hits harder than any siren. Gavin wasn't just fleeing the police, he was trying to reach his daughter. A custody situation, a ticking clock, and the fear of losing access to his child. That one decision to keep driving wasn't about lawlessness. It was about fatherhood.
Panicked, he explained, he was honest, he explained what was going on. He did mention trying to get to the daughter. I think his head was just not in the right space, and he made a very, very, very bad choice. But ultimately, he was cooperative, and ultimately, he's here taking responsibility. I think that having this, albeit a misdemeanor, a Class A misdemeanor conviction on his record is going to serve as a reminder to Mr. Jones about what happened here, and should he have criminogenic needs that can be addressed, those can be addressed on probation. I think that'll keep the community safe.
All right, thank you.
I can add a couple things to that, Judge, if you'd like me to, or I can wait until
You can wait until argument.
Okay.
Has there been any discussion about expunction, and or has there been any charges filed in Minnesota?
Both. Those are the two things I was going
Oh,
to mention.
Alrighty then.
And I was also going to mention, since I'm at it, that you had 4 days custody credit in Wisconsin and also had some custody credit in Minnesota. They only gave 1 day credit, but he tells me he was in jail for more than a week, and I think that's probably accurate from what I can figure out. 2 things. Yes, I was going to request and will request expungement for successful completion. He still has to get his probation completed successfully. But what happened in Minnesota was he ended up pleading to a felony charge there. He's on probation. How long are you on probation for there? Minnesota?
3 years.
3 years. So he will have that measure of supervision, but it's one of those stay of adjudication, so that if he successfully completes that, it'll end up being a misdemeanor.
We now enter legal limbo. Gavin has charges in 2 states for what's essentially one series of bad decisions. Minnesota got the felony plea. Wisconsin is handling what's left. And so the big question, does this court trust Minnesota's punishment is enough, ... or does it add more weight?
So that, coupled with this, is probably a fair result for the overall situation. And I will explain again in more detail what happened that led him to start this course of conduct that evening.
All right, thank you. Can I have the plea questionnaire waiver of rights form, please? Thank you. All right, I have the plea questionnaire waiver of rights form. Mr. Jones, did you go over this document with your attorney?
Yes, Your Honor.
Did he go over it thoroughly with you?
Yes, Your Honor.
Did he essentially read it to you word for word?
Yes, Your Honor.
And so you understand everything on that document?
Yes, I do.
And if you did not understand something, did you ask him to explain it to you?
Yes.
And he did so.
Yes.
And so you're telling the court you fully understand everything on this document.
Yes.
You were pleading guilty to 1 count of operating a motor vehicle and disobeying an officer's commands under Wisconsin Statute 346.04, paren 2T. You're 23 years old, you have 12 years of schooling, you can read, write, and you understand the English language. That's all correct.
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over?
Here comes the legal tipping point. Gavin admits it all. He knew it was a cop, saw the signals, and still chose not to stop. This is the moment where the court tests sincerity. No denial, no dodging, just a straight-up guilty plea. And that kind of honesty, it can matter. Big time.
Possible penalties you face.
Yes, Your Honor.
You are receiving treatment for a mental illness or disorder. Is that something that interferes with your ability to comprehend or understand what's going on?
No.
So you're in a position here today where you fully comprehend and fully understand everything.
Yes, Your Honor.
You are not taking any medications, and you've not had any alcohol or other drugs, correct?
No, I have not.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Next to the rights is a box, and each of those boxes is checked. That tells me that your attorney went over those rights with you, and you understand them. Is that correct?
Yes, Your Honor.
So you fully understand those rights.
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that the state would have to prove on or around May 4th, 2024, that you were an operator of a vehicle and you received a visual or audible signal telling you to stop your vehicle from a traffic officer or a federal law enforcement officer or a marked or unmarked police vehicle that you knew or you should have known was an officer and being operated by an officer, but you knowingly resisted that officer or obstructed that officer by failing to stop your vehicle promptly and in a safe and reasonable manner. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you do face a fine of up to $10,000 or imprisonment of up to 9 months of incarceration or both?
Yes.
And do you understand that the recommendation to the court is to place you on 1 year of probation with what's called a withheld sentence? That means to have the whole entire 9 months held over your head instead of telling you today what the sentence could be if you're revoked. Do you understand that's simply a recommendation to the court?
Yes.
Said differently, do you understand that I could sentence you today all the way up to that maximum possible sentence, which could be that maximum possible jail time if I thought it was warranted? Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And that's that original document that basically says what happened that day and why you were charged with those crimes.
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did fail by resisting or obstructing, fail to pull your vehicle over after being prompted by a law enforcement officer through either audible,
Yes.
and you knew or reasonably should have known that it was an officer?
Yes.
Mr. Amon, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Has anyone made any threats or any promises to you, Mr. Jones, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing here today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Formal motion to amend count 1, Ms. Rockow?
So made.
Court will grant that motion. As to the amended count of obstructing an officer by failing to turn your vehicle over or by use of vehicle, at Class A misdemeanor, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Counts 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Ms. Rockow.
Your Honor, I'd ask the court to adopt our joint recommendation and withhold sentence, place Mr. Jones on a period of 1 year of probation. For the reasons that I've already stated, I believe this to be in the public interest. Thank you.
All right, Mr. Almond.
Well, this is I'm going to start currently. Mr. Jones was pulled over within the last couple of days, and actually pulled over before the cop even put his lights on because he wasn't going to let this happen again. Ultimately, after they maneuvered around each other a little bit, there wasn't any issue, any problem, and Mr. Jones has already reported that to his probation agent in Minnesota. So his behavior is quite different than it was in this particular evening. But what he explains to me is that he stopped for gas in Hinckley, and he was on his way home where his daughter was, and he and the daughter's mother were having custody issues at the time. And had he not gotten there on time, the mother would have ended up with the child, and there would have been issues wrangling back and forth about that. And have I got that so far?
Yes.
And when he started to pull over, and then all this business went through his head about his daughter, and he basically tried to get away. That's how the as warped or wrong as it was, that's how the thought process went into this. And yes, he said he panicked. I think he was straight up with the officers and the whole thing, and he did what he needed to do here. And I think with no criminal history at age 23, it's really I think it's an aberration of behavior that was dictated largely the circumstances. He also does suffer from depression, and I don't know if that played any role in the thought process or lack of thought process at the time, but he's now received medication for that and is just starting to take that, so hopefully that will never be a problem for him again, at least not that he can't address.
Thank you. What happened with the child? Did you have to go to family court, and did this
The issue,
cause an issue?
the issue wasn't with my wife at the time, it was with her roommate. I had reason to believe that he was abusing my daughter, so I didn't want her going back to her mom's house. Which she ended up going back to her mom's house. And then I convinced her to move to her mother's house instead to get her away from him. And we are actually back together now. We live in Grand Rapids.
You're back together with your wife? Or...
Yes.
Yes. Well, that's good to hear. So you've been able to work through those problems and those issues?
Yes.
And so you said Grand Rapids, and that's an address we have. Are you still in apartment 33 then?
Yes.
Excellent. Okay. Well, I'm really glad to hear that. So I'm glad to hear that you were able to work out the issues that you had with your significant other, and that you're working towards having a stable relationship with her and with your child. So that's good to hear. Is there anything else that you want to let me know? You want to fill me in on? You don't have to make a statement or tell me anything, but this is the only time that you have to let me know anything.
Nothing I can think of.
And Mr. Almond, so I can understand that the crimes that he was charged with here in Burnett County, this is the same day exactly as the crime, that felony he pled to in Minnesota, correct?
It was a continuation of the same events, I think.
And that's what I believe to have occurred. So, Mr. Jones, when a court sentences an individual, there are various factors and various things that come into play. First and foremost, I have to look at the seriousness of the offense. Then I have to look at the individual in front of me and various factors among them: your age, your criminal history, your mental capacity, your health, those types of things. I also have to look at the need to protect the public interest. I also have to look at if you have any rehabilitative needs and if they're being addressed right now, if you have the ability to address them in the community, or if this is something that I need to look at deterrence, deterring you from doing this again, deterring others from committing the same or similar crime. There's a lot of things that come into play when a judge sentences an individual. And I'm sure you're aware of that. Even though you don't have much of a criminal history, this is your criminal history. This day is your criminal history. I'm sure it was similar in Minnesota when you were in front of the judge. Seeing a very young man, a 23-year-old who was under a lot of stress and trauma at the time. You had a lot of fear, a lot of anxiety, a lot of things going on that day on May 4th, 2024, when you believed that something was going to occur or happen with your daughter. Now, did you violate the law? You sure did. Did you put others at risk? You sure did. And so that's why I do see a little bit why the reckless endangering was initially charged, because it could have. You were driving at such a high rate of speed, you could have endangered somebody's life. If something would have occurred, if something would have jumped out at you and you swerved your car, you could have hurt or killed somebody during that process. So it is a serious crime. But you don't have a criminal history. You're young. You are looking at doing something with your life. Are you working? Are you going to school?
I'm working as an HHA at an assisted living, and I was looking at going to college to become an RN.
Excellent. That's very excellent. I'm very glad to hear that. We need more good RNs, registered nurses. We need people who, but you have to be very attentive because the nurses, really for real, they're the backbone of the whole medical field. They really are. I want you to be able to do that. So when are you looking at applying or starting school, starting your associates to build towards getting your RN?
I was hoping to start college the next semester that's available in the fall, I think. I live a 5-minute walk from the college.
Oh, that's even better. That's good to hear. This day of May 4th, 2024, this day, you are a risk to the community. I think and I believe that you have made some changes in your life and you now have a better understanding of what occurred that day and the risks of what could happen if you were to do this again. And the fact that if you were to do this again, the fact that you were charged with these charges, they just don't go away. They stay on CCAP forever. They stay in law enforcement's databases forever, and they can see and they can look and say, okay, he has done this before. Maybe this time is the time that we need to be cracking down hard on him. But I don't think this is the time to crack down hard on you, because I really think that you've already been cracked down hard on in Minnesota by pleading to a felony and being on probation for 3 years there. You're from Minnesota. You're on probation for 3 years. You check in with your agent. You meet with your probation agent. You're doing the programs that your agent is telling you to do. You're doing all that you should be doing in Minnesota. I don't see what double probation is going to do. I don't see what it's going to help by having Wisconsin also supervise you, also spend the resources to provide you with services or to make sure that you're following the line and not committing crimes. I'm going to guess you were just kind of driving through Burnett County. This wasn't even some stop of yours, correct?
Correct.
And so this was just a happenstance. So you're not a risk to Burnett County. And so based upon that, although if it were somebody else with different facts and different things to look at, I would do a different decision. But my job is to look at the facts in front of me, the person in front of me, the things that happened and occurred, as well as to look at what happened in Minnesota and what's happening there now and will for the next 3 years. So what I'm going to do is, I didn't say it before, but all of the TR matters are dismissed and read in as well. I'm going to assess $750 for a fine, 5 days of jail, 4 days jail credit. That means it's a time served. Double probation you. You're already on probation in Minnesota. Do what your probation agent says, because if you do what your probation agent says, you're going to have your felony go away, and that's going to help you be an RN. If you don't, it's going to be difficult for you. All right? So even though this was different jurisdictions, it really resulted out of the same crime. And yes, you can be punished twice, and you kind of are. You've already pled guilty to a felony. That is on your record at least for 3 years. And I'm taking $750 that you could probably use. So $750 cash. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You do owe for Mr. Amen's services, and I don't know what that is.
No, he's PD appointed.
Oh, he's PD appointed. Sorry. Okay, so you don't owe for Mr. Amen. But I need your DNA. When you're done here, you have to go right over to the Sheriff's Department, provide your DNA, and then you should be free to go. You have the right to request it be expunged through a written letter to the Department of Justice, not here, to the Department of Justice, if you wish to do that. I think that covers everything. Ms. Rockow.
Nothing more from the state, Judge.
Mr. Almond.
I think you noted the 750 must be the amount based on the amount